me see that. I like you already, Ashley. You got an Apple MacBook Pro.
I'm an Apple person.
You know you're one of the minorities, right? Most attorneys have their...
No, I actually, my last laptop, it completely broke unannounced 2 months after my 2-year warranty ran out.
Right.
And it was 2 days before I had to do my first full trial for Triad. So I finally switched to a Mac because I wanted one, and I already had an iPad, and I think the iPad won me over. I still have the first generation, and the only thing I am missing is an iPhone because I have T-Mobile, and they're finally getting. I try to leave them every month because I want iPhones so bad, and they keep on knocking down my bills, so then I can't leave them. But they get it next month.
Well, that is great. Well, let me just make you feel at ease because you're one of the few candidates that actually responded to what we asked for. You'd be surprised. When you ask for a few things, they go off point and they talk about other things. But you were very clear about getting through the issues. And quite concisely, if I might add. So the hard part is done. Now give the oral presentation as to what you put together for us.
Okay.
I'm looking forward to it.
Okay. Well, the first thing, I think in this case, defense counsel, they had an ample opportunity to prove the lack of standing. But they failed to do so. First, they didn't follow the court's order. They didn't follow the instructions. They asked for 3 simple things, whether or not Illinois or New York law controls. What are the laws and how they differ, and whether for standing the imperfect conveyance or the failed conveyance makes a difference for void or voidable. They did not address any of that, and the court pointed that out. The issue in this case is the court itself had no idea what their stance was. And because they could not come up to with a decision themselves, they based their decision on the lack of the burden of proof. So this case is definitely an example of poor lawyering on the defense counsel's point of view. If they were aware of New York law actually was, the court did a very good job of pointing out how they couldn't even define person in the statute. If they were more aware of what New York law actually was on the issue, I think they would have had a better opportunity to distinguish the case law that the court provided as well as come up with a valid argument. As far as what the New York law was and how they failed to distinguish it, I think the counsel on the defense's side was very driven by the legal analysis of the case law provided initially by the court, and I think they failed to look at the facts in their research. They strictly focused on the law and not the totality of the circumstances. In regards to the case law, the best argument they can come up with for void or voidable was the fact that there is no proof of ratification, and that was, they were missing the point. The issue with it, as far as what Illinois law is, this statute defines that a mortgagee is obviously the holder of the indebtedness or obligee of a non-monetary obligation secured by a mortgage, and any person claiming through a mortgagee is a successor. I think they missed the point. I think they failed to start from the beginning that the mortgagee that was not the mortgagee. So therefore, that the assignment was non-existent. It was invalid. There never was an assignment made. So therefore, it was void. I don't know if you could see that. As far as case law for Illinois for assignments, some cases that stand out is Deutsche Bank versus Gilbert, and I wrote an article on that initially with my application, that the trial court erred by granting the summary judgment because it lacked standing on the date it filed for foreclosure. And the court pointed out that they failed to comply with the Supreme Court 191A because they did not state how they knew that the assignment took place in November, and they failed to have the documents attached to the foreclosure action. Furthermore, in Bayview Loan Service, the entry of summary judgment for limited liability was an error because the record contained no assignment of the mortgage to the company, to which the record showed the mortgage had been assigned by the original mortgagee, and the two entities were distinct. And finally, in Winkleman, the plaintiff in the foreclosure action must have a beneficial interest in the mortgage. Illinois law clearly states that the instrument of the trust governs. In New York, as far as the case goes, they concentrated on Statute 7.2.4 of New York law, which states that any act in contravention of the trust is void. Here's where the issue in the case becomes. Based on the case law cited in the case, and how they define void versus voidable, I think the issue is that in case law, they're used interchangeably, even though they are not. And defense counsel failed to look at the facts and circumstances of each case cited by the court in order to decide whether or not they could prove that that the assignment of the mortgage was in fact void. As far as the argument of securitization fail, I don't think defense counsel strengthened their argument that the fact that the loan was never securitized. And if they went through everything and followed the right money trail, I believe they would have succeeded, because if they, like I said, if they, based on the facts and the details of what happened and transpired through the conveyance and the transaction, they would have been able to adequately argue that no transfer ever existed. So transfer was void.
Ashley, are you suggesting that the money trail is more important than the signatures on the conveyance?
I definitely, with what's going on with the financial crisis, definitely more important than the paper and the signatures, because as we already know that many of the paper trail and many of the signatures are in fact fraud, and that has already been proven. Many of the major mortgage bank lenders have been using these doc mills where they have been fraudulently producing paperwork in order to foreclose on properties. Ever since the subprime mortgaging issue, I believe that once they electronically switched mortgages, that proper paperwork was not done when mortgages were created, just because they were creating them for commission. They were creating them to get, to churn up as many mortgages as they can, and in that mess, paperwork, signatures, proper notarization papers, they were lost. So I do think that the money trail is more important than the transaction of the finances, especially when you have these creditors buying these mortgages for pennies on the dollar. And here's a case, in Illinois, case 1922, case McGarry versus Village of Wilmette, that points out how frequently void and voidable is used interchangeably by the courts, and you do have to really go into that case law and find out what meaning they're actually getting at, because that is definitely what the defense counsel failed to do.
Are you suggesting that this is going to be a rabbit hole, that we're going to uncover 20 to 40 cases all using interchangeably terms, and we're going to be arguing about what case means?
I believe so. I think the strongest proof of that is many of the cases citing cases that were the opinion were written prior to 1923, and prior to 1923, I think void and voidable in contract law, the terms were used more interchangeably than they are now. There wasn't a set document such as the restatement that set out the definitions and how exactly they were to be utilized. And I believe that once that case law prior to the restatement has, once those opinions have been published, I think we are still reliant on some of those opinions.
What year did the restatement come out?
I know that the institution was formed in 1923. I know that they worked on it for several years. I'm not exactly sure when the first one came out to be exact, but I know that the main priority was to set forth.
If we said that the start of securitization started in 1980, how many void versus voidable case law would we see since 1980? What would be your guess? I know you haven't looked at it.
I would not be. And how many cases since 1980?
Yeah, in the spirit of securitization, because I'm making the assumption that the securitization fail argument really starts in 1980.
Right.
So you can almost knock out anything that has case law before 1980 and focus on the spirit of the law, what was intended for a Remick trust.
Right. As far as a number of cases, I would be uncertain about that. As far as prevalent case law, we have Wells Fargo Bank versus Farmer, and that's for the transfer of property of the trust to be effective. The transfer must be done under the terms of the instrument creating the trust, and the transfer must designate the particular trust and beneficiary. Without that, the assignment of the mortgage note is without merit. Also, you have Hermans versus Robertson, and the court hold a court of equity will not allow a trustee of such a trust or of any trust by postponing or accelerating a sale to affect the interests of the successive trust. By doing so, a trustee could, by fraud, or which we have going on right now with the mortgage issue, defeat the intention of the trust and deprive the rightful owner of his trust rights. And the defense counsel clearly missed that here because they didn't. If they addressed what the real issue was for the trust as the holder of the mortgage to the beneficiary, I think they would have gotten that an invalid transfer or assignment is void rather than voidable. In Dye versus Lewis, the court addressed this case initially when it defined the New York statute on the issue. However, they disregard it completely and go into the case law that distinguishes that statute. However, I think defense counsel failed to realize, because they were too focused on the actual legal analysis, that the facts surrounding the Dye versus Lewis case, they actually were very on point, and they were not able to be distinguished compared to the courts that the cases that the court relied on. Dye versus Lewis dealt with a mortgage and mortgagee-mortgager relationship, unlike the other cases relied on by the court. And in that case, the authority of a trustee to whom a mortgagee had been delivered under a trust indenture was subject to any limitations imposed by the trust instrument, and every act in contravention of the trust was void. The necessary parties to a foreclosure action are those interests such as the record owner, a person having a estate or interest in the property, or one holding a later lien. I don't know if I should wait.
Keep going.
Okay. And like I said, the distinguishable cases, they don't really address the facts and circumstances of what is going on with the foreclosure crisis. They really heavily relied on Mooney versus Madden. And then there...
Do me a favor. Back up to that last case and tell me why they should have relied more on that.
Well, I mean, we were dealing directly with a mortgagee and mortgager relationship, whereas the cases that the court relied on was not. They were dealing with board of trustees making a vote on a decision, a trustee himself sending out a loan.
Tell me how it fits
And
in with the truster.
With Dyer versus Lewis, you have a foreclosure action and the trustee making transfers that were not authorized.
Okay.
And the cases that the court relied on, they did not. They had nothing to do with the mortgagee-mortgager relationship. Mooney versus Madden, the trustee, it was about a decision that the board members, voted on, even though it was, outside of the trust. Feldman versus Torres, Torres, we're dealing with a loan being signed to a creditor by the trustee himself. So I believe that, if the defense counsel really focused on the facts of each case and distinguished them, they would have been probably prevailed, in my opinion. So I do believe that even though this case was not, found in favor of the borrowers, it gives us a significant opportunity to address the issue of void versus voidness, and with proper distinguishing of the facts and circumstances of each case, we can prevail based on this case. Also, the defense lawyers, by not alleging the proper facts and circumstances, by not following that money trail, I think they could ceded the case themselves because they did not meet the burden and they did not answer what the court was looking for.
Do you think when we make this argument, we can take the cases relied on by Bassman, the New York cases, and put them all into one box and then attack that? Or do you think we've got to do more than that?
I think you could start by doing that because they're definitely distinguishable.
What would the attack be in the box?
Well, the attack is the fact that the Bassman case law used and relied upon is completely distinguishable to the current situation that we have on hand. Because this issue is, of first impression. There wasn't even substantial Illinois law on the issue, and the fact is litigation. All this litigation is coming from the avalanche of foreclosures. We have a situation where we had banks just fraudulently assigning these mortgages, and we have proof of that. However, the holder in due course, we can't, claim fraud on, a borrower cannot claim fraud on that if they're the holder in due course of the note. So I think in retrospect, we have to take each facts and circumstances in the case and distinguish, especially in the cases used in Bassman, how they are different. Most of the cases don't address the mortgager and mortgagee relationship, and further, most of them don't even address the situation in regards to the mortgager conducting fraud themselves. Definitely, from a criminal aspect, this is going on as well. So, you have, there are, those involved in mortgage fraud, they are getting the books slammed on them, whereas the banks are not. The government federally, they are, they're able to settle civilly and also be immune to prosecution, and I believe that is also a point to, bring into light, and I think that future litigation in regards to this the law is going to constantly change, and it's constantly going to be evolving because this is such a new issue, and this is such a new facts and circumstances that millions of people are faced with right now.
That's great, and I like that a lot. You got questions?
I'd like to ask you what your take on the Wooten podcast was.
It actually reminded me of an attorney I'm talking with. He actually has been all over Europe, all over the West Coast. I don't know how I started talking to him almost as a mentor, but he reminded me so much of him. He actually is, he sent one of his associates, or an attorney that he has a relationship with, was on a case in regards to Deutsche Bank. I actually got the opinion of the appeal sent to me by him last night, and it's actually very interesting. I wanted to print it out, but after moving, I didn't have enough ink to print out the whole opinion, but it's definitely really exciting to the criminal case that I have worked on. And I think that the podcast, the way he's such an advocate, definitely is something that I want to be a part of. And the attorney that I have been, basically I contacted the associate on the case. I read, a transcript of Jolly, and the case that I'm dealing with, it's a mail fraud and money laundering case. However, it's directly dealing with mortgages that were taken out initially through WAMU and JMAC, and now, the U.S. attorney is claiming that the victim loss is owed, millions of dollars owed to Chase. So, I've been, through research, I found this transcript of a testimony, and in the testimony, because if you go online to the FDIC website, there's a purchase and assumption agreement between Chase and WAMU. And then I found through research a testimony stating with one of the officers with WAMU, and I believe that one of his signatures were on the original purchase and assumption agreement. He actually testified that the one on the website isn't complete, the 39-page one. There's actually a 118-page, and the text of that is actually it's not what the text is of the one that they released to the public. And the U.S. attorney told us that we were liars, but in the actual case, it's Chase versus Jolly. I don't know if you guys are familiar with that. And so I've been talking to this attorney who had a connection and he's actually in Europe doing lawsuits against Deutsche Bank, and they are actually getting slammed for fraud over there. So it just, his enthusiasm over the subject and everything he said just reminded me so much of him. And basically it was just, the case was, summary judgment was granted for Chase initially in the case, but the testimony stated that he has signed and read a full 118-page agreement and was contrary to the one that's the public was released to, and everyone said that, his testimony, it was incredible. However, when it was subpoenaed, the purchase and deception agreement was subpoenaed, FDIC didn't deny that wasn't the full one, yet they issued, if you sign a confidentiality agreement, then we'll release it. So that was part of our argument at the sentencing hearing. I was at a sentencing hearing in December, and when we got to this point, the judge just, I don't think she knew what was coming. So she didn't know what our defense was. She just put her hands up and she said, I want that in my hand, and this is continued. So now, the sentencing hearing isn't going to occur until April 1st. I don't know if the firm, the owner of our firm, wants nothing to do with this case because we're upside down on it, and so he almost told the other attorney and I that we're not allowed to work on it on his time. If we wanted to work on it for free, we can, and he's not funding it anymore. So I don't know if he would fly me down there, but I definitely want to be there on April 1st. What happened is we called a Brady violation on the U.S. attorney because it's, the same employer as the FDIC, so we...
And does she think it's going to be a big enough violation to overturn the underlying judgment?
Well, I think our whole point is he was found guilty in trial, and I think the evidence did establish beyond a reasonable doubt that he was guilty of the fraud, as far as fraudulent W-2s through applying to the mortgage. Even though he was just a pawn in his mother's, his mom's scheme, clearly the mother was, but, so I do believe he was guilty. However, I believe the issue is the fact that they are penning $1 million victim loss and want to put him away for 5 to 7 years as opposed to 4 to 7 months. And that is our stance, is that we're trying to wipe out the 16 points that has been assigned based on the victim loss, because our claim is there is no victim loss. In fact, these banks probably, profited off of the sale, the foreclosure. And the interesting thing is, I want to, looking through the mortgages, and the history of it, is actually the foreclosure sale, according to the records of the properties themselves. After the foreclosure sale, the property, there's 4 properties in question, the property was bought, according to the records, by WAMU after they have already been shut down. So, that in itself, it's just everything that is going on. It's definitely, I think it's going to be a new wave of litigation, and definitely new laws are going to evolve because of this. So, it's just going to take attorneys that are willing to be advocates for what is going on, and eventually there will be change as a result of what happened from the financial crisis.
2 more quick questions. One, how much time did it take you, start to finish, to put this together, do you think?
Well, I'm pretty obsessive with the issue. I've, especially like the Lost Bank and books I've read in regards to the criminal case. As far as the
just on this.
On the research, I probably spent, more than a day researching, Illinois and New York law, because,
how long did it take you to write?
To write the actual memo, it probably took me a couple hours. And once I have all my research, I'm a pretty quick writer.
6 to 8 hours research, a couple hours to write.
Right.
You have any other questions? I just have one more question, but go ahead.
Fire.
Why should Ted hire you?
Well, I think, one, my passion for this subject will motivate me to do very well. I clearly want to be a part of what is happening. The reason why I became a lawyer, was a direct effect of what happened in my personal life, and I think that has made my whole attitude about being a lawyer is being an advocate. and helping others. I think 90% of being a lawyer is holding people's hands and helping them through the tough situation, because mostly your clients are going to probably be going through one of their worst times of their life, whether they're getting foreclosed upon, whether or not they're facing criminal charges, or whether or not, they just broke a leg, in a car accident. So I really believe that I have that compassion, to be an advocate for my clients and not just be someone who recites statutes from a book. And I believe that my current interest in what has been going on.
I'm sorry, but that was just such a good line. The way to describe transactional lawyers.
Right.
Yeah.
Okay.
That's why I never want to be a
Cites
transactional lawyer.
I just, I thought that was great.
I don't want to be a transactional attorney. Apparently.
Well, my situation is this. I am. I thought I was only going to hire one person, and I wasn't sure which way I was going to go.
Mm-hmm.
My view now is that I may hire, and I may hire 1.5, and then turn that into 2. What I'm sort of looking at is somebody who's been out and has a good solid year or 2 of real experience, so they can go right in, do my motions, do all of the stuff, and they have familiarity with all of that. And I'm also looking for a person out of school who can do 20 hours a week for 60 to 90 days. Part of that's our fault. I mean, part of that is, hiring 2 attorneys instead of 1 is not our fault. But the hiring problem is that we're just not capable of managing that much all at once. I mean, to manage 2 people all at once and then give them all his assignments and do all that stuff, very difficult. To manage 1.5 is a lot easier, because part of that's going to be a flow down from the 1, okay? And so I don't know how you would feel about that. I mean, our desire here is, as we look at this and as we look at our workload, we're talking about 60 to 90 days, and either we bring that person on or we don't.
Let me give you the Cliff Note version.
Let me finish. That if we don't, our chances of not doing that mean that we have really screwed up the interview process and whatever, and we have a lot of really interesting, really talented people. Hopefully not. I mean, that's an issue of fit more than it is an issue of intellectual capability.
Bottom line is, you've created a problem for us. We really like you. I mean, short version.
This was the job I was looking
the issue
for.
The issue that Ted was addressing is he's leaning towards someone who's got 2 or 2.5 years of litigation experience in the courtroom. That's something that you don't have. What you do have is something that we like.
Okay.
And that's your ability to be passionate about these activities. So we're trying to figure out, how do we think outside the box and get to...
Well, I definitely, as far as litigation, not as, because I'm a newer attorney. However, all my internships were based on litigation with the state's attorney. I did my own trials. I did my own motions. I definitely, as far as in a new area of law, I definitely would feel more comfortable observing, for at least, a couple weeks, at least a few of them before I felt comfortable. But I am very comfortable in a courtroom, as far as, but, I do understand that, as to be thrown in there, I definitely would need a little bit of guidance, because litigating these type of motions would be a new thing for me. But I definitely have courtroom experience.
Since you left us, have you responded to other posts? Are you looking at other opportunities? To give us an understanding what your...
I had a interview already scheduled 2 days after my first interview here. However, I left it thinking, I hope they didn't like me too much, because I'd rather do this type of work type thing. Like, clearly I'm going to try to look as aggressively as possible, because I need to financially support myself. But
out of curiosity, what kind of law was that?
It was personal injury. I'm clearly only looking at jobs that are based off litigation. Right. However, this is the only job I applied to that combined what I have become passionate about. So clearly, it's the one I really want.
So you're out there, you're looking. What we're asking now is,
right.
would you be open to a situation where you slowly migrate into our firm.
That would be completely okay with me.
And we're thinking 20 hours a week, get you in, get your, certainly in the 60 to 90 days, we're going to be in a position of deciding how we go forward. That way we get an opportunity to see your work, you get an opportunity to say,
I think
shoot, you might find out you don't like working with Tim.
Right. I mean, that definitely is the perfect opportunity for me.
Okay.
To work myself in. I just moved back, so I mean the job hunt. I just started, and
Okay.
when I saw your ad, I knew that was exactly the type of job I wanted. So even in 20 hours a week, I'd be completely
Okay.
grateful. I do on the weekends pick up bartending shifts to help pay my bills. So that definitely the 20 hour.
Yeah.
If I crossings in Lincoln Park, so if I had. That would still enable me to do so I can still have a complete income, because I am still doing stuff for the Florida firm at Wells, so
Right.
maybe...
And we want you to do that because that can't hurt us.
Right.
Because the more you understand that WAMU situation, we have 4 or 5 cases that are WAMU cases.
Right.
At least.
So yeah, I definitely would be very happy to have that.
Thank you.